Okay, today in this honorable court, we will be hearing the fact of the case of Dr. MKVS against Bar Counsel. Now, the counsel for the appellant can deliver your facts.
May it please the Honorable Court, this case concerns a commencing transaction, and actually it's not due to dishonesty but due to miscommunication and unforeseen financial complexities. So my client here, partners at Blanche Cavius and Co. acted as stakeholders solicitors for the vendor, Avocado Corporation, in the sale of land to Jordan Corporation. So the stakeholders funds 621,254 cents were received on 23rd August 1996 from the purchaser solicitors. So this were meant to be held until redemption of the property from Hong Kong Bank was completed. However, the redemption process was delayed due to disputes over the bank's redemption figures. So in the interim, based on instruction from the vendor's managing director, a portion of the funds 195,199 and 94 cents was released. So the appellants admit that the release of stakeholders' funds was not fully in line with the agreed terms. However, they stressed three important points. First, there was no dishonest intention behind their actions, because the money was released based on the vendor's instruction and not for any personal benefits. So secondly, the purchaser was fully repaid the amount of RM 195,199 and 94 cents. So the matter was actually also resolved through a consent judgment in court, which closed the issue between the parties. So because of this, the appellant submits that their actions actually amount to a civil mistake and not professional misconduct. And they believe that disciplinary action is not necessary as there was no fraud and no loss to the purchaser in the end, and the issue was settled properly in court actually.
Thank you, appellant. Now, counsel for respondents can submit your facts now.
With respect, Your Lordship, the appellant's solicitor were not merely agents of the vendor. They were the stakeholders with fiduciary obligations. They were the trustees of the balance purchase price, bound to hold the funds until the redemption of the charged property. The facts are not in dispute. RM 195,199 ringgit and 94 cents was released to the vendor's managing director. This was done without consent from the purchaser, and the release occurred before the redemption, contrary to the clause 4 of the sale and purchase agreement. The core issue is this: the misconduct exists not only in dishonesty, but in failure to uphold professional fiduciary duties. Even without intent to deceive, the appellant breached the trust, and that alone amounts to misconduct under the Section 94, Clause 3, Clause O of the Legal Profession Act. The Disciplinary Committee, the High Court, the Court of Appeal, and finally the Federal Court all found the appellant's action were a serious discretion of duty. A stakeholder owes a money in trust not merely on contract, and professional standards demand strict compliance. Therefore, the 5,000 ringgit fine per partner was appropriate and necessary to uphold the integrity of the profession.
Okay. Any closing remarks from the counsel for appellant?
Yes, may it please the Honorable Court. From the appellants, we actually stated that the appellant have already suffered financial and reputational loss. So why they accept the breach occurred? They respectfully submit it did not rise to the level of misconduct, especially given the absence of dishonesty and that the loss was fully restored.
Okay. Now we move to closing remarks from counsel for the respondent.
With respect, my lord, the fiduciary duty once breached is not excused by the repayment. The lawyers must be held to a higher standard. Upholding the decision affirms the bar's commitment to ethics and trust.
Thank you, counsel, for your submissions. After reviewing the facts and applying the relevant legal principle, I am now ready to deliver the court's decision. This case revolves around the conduct of the defendants, Dato' M. Caviers, and his colleague, who were appointed as stakeholders in a property transaction between Jordan Corporation and Avocado Corporation. A total of RM621,254 was entrusted to them to be held pending fulfillment of certain conditions. However, the courts find that a sum of RM 195,199 and 94 cents was released by the defendants, not to the vendor company as agreed, but to its managing director without obtaining proper written consent from the purchaser. This clearly breached the term of the stakeholders' agreement. Even the defendants argue there was no dishonest intent. The law is very clear. In the federal court case of Dato' M. Caviers against Bar Council, it was established that solicitor acting as stakeholder do so in the capacity of trustee. Any unauthorized release of fund is not just a contractual issue. It is breach of fiduciary duty and therefore professional misconduct. The court also takes notes that defendant later agree through a consent judgment to repay the full sum, which further support the conclusion that a breach occurred. Therefore, the courts find in favor of the plaintiff. The defendant are ordered to first pay the sum of RM 195,199 and 94 cents to Jordan Corporation. Second, include interest at 8% per annum, calculated from 13 November 1997 until full payment is made, and bear the legal cost of these proceedings. So this case serves as a firm reminder when entrusted with client fund, especially in a stakeholder role, solicitor must act with utmost care and integrity. Any deviation, even without dishonest intent, can have serious legal consequences. That is all. This session is now concluded. Thank you.
Assalamualaikum, my name is HANI NISRIINA and I will be explaining on the court's finding in this case. The federal court in this case has affirmed the decision made by the disciplinary committee and later reviewed by the disciplinary board of the Bar Council, which had found the appellants, who is Dato' M. Caviers and another partner in his law firm, had committed misconduct as defined under Section 94 Clause 3, Para O of the Legal Profession Act 1976. The section is a catch-all provision that allows the Bar Council to take disciplinary action against an advocate and solicitor for any conduct unbefitting of an advocate and solicitor, even if the misconduct does not fall within the more specific categories listed in the Act. So in this case, the misconduct stemmed from the unauthorized release of the stakeholder funds that the appellants were holding on behalf of their client during a conveyancing transaction. The disciplinary board had already determined that this action violated the professional standards and conduct expected of lawyers, and the federal court agreed with their finding, thus affirming the penalties imposed. Therefore, to conclude, the federal court had upheld the decision made by the disciplinary board and the disciplinary committee, which had found the appellants guilty under Section 94 Clause 3 Para O of the Legal Profession Act 1976, and emphasized their solicitors holding stakeholder funds are not merely in a contractual relationship but owe a fiduciary duty akin to that of the trustees. So the appellant's failure to adhere to the terms of the stakeholder agreement was deemed a breach of this fiduciary duty regardless of any dishonest intent. Consequently, the court have affirmed the disciplinary action taken against the appellant. That's all from me. Thank you.
Next, I will explain further about the legal principles applied in this case, which revolves around the laws surrounding legal professionals in Malaysia. First, the breach of a stakeholding agreement is a breach of fiduciary duty. The Federal Court in this case affirmed the finding of the Court of Appeal and the High Court, stating that, in our view, the factual background attacks the application of the principles of law regulating stakeholders. The breach of duty by the appellants as stakeholders is not a mere breach of contract. The relationship between the appellants, which is the stakeholders, and the vendor and the purchaser is fiduciary in nature, existing between trustees and beneficiaries. Therefore, the appellant's breach of duty as stakeholders is a breach of duty as trustees. It is a breach of fiduciary duty. Once it has been established that a breach of undertaking is a breach of fiduciary duty, it must be determined whether a breach of such nature amounted to professional misconduct. In this case, the Federal Court referred to the Countrywide Banking Corporation vs Kingston case, which state that a breach of undertaking is itself misconduct and a serious dereliction of duty. According to the Federal Court in this case, the deliberate breach of undertaking by the appellants falls under Section 94 Clause 3 of the Legal Profession Act 1976, despite not being enumerated under any of the categories listed under the section. This is referring the case of Au Kong Weng vs Bar Committee Pahang, where Raja Azlan Shah, as he then was, stated there are no closed categories of professional misconduct. It is clear through the word includes in Section 94 Clause 3 that the Parliament had not intended for categories A through O to be the only repository for instances of misconduct by a legal professional in Malaysia. Furthermore, Raja Azlan Shah in Au Kong Weng enunciated the following. One of the most fundamental duties of an advocate and solicitor, recognized for as long as the profession had been in existence, is that he must honor to the utmost the promise or undertaking given by him in a professional capacity to the court and to members of his profession, and failure to honor it is regarded as a breach of professional conduct. Therefore, under Malaysian law, specifically under the Legal Profession Act, the breach of undertaking committed by the appellants is considered a professional misconduct. That is all from me. I will move on to the next presenter. Thank you.
Now, I will discuss about the legal impact of the case. First of all, this case reaffirms that lawyers are not merely service provider, but they hold a position of trust that demand absolute loyalty, integrity, and transparency. In situations involving conflict of interest, personal gain, or misuse of influence, this duty even become more pronounced. The court emphasized that legal practitioners must avoid conduct that could damage the dignity of the profession or erode the client confidence. Lawyers are required to act not just lawfully but also ethically, even outside the courtroom. Their duty go beyond the four corners of a contract. A breach is not simply civil liability, it constitutes ethical and professional misconduct. Secondly, the case solidified the Bar Council authority as the regulatory guardian of the legal profession. The court acknowledged the Bar Council role in maintaining professional standards and ensuring that disciplinary proceedings are enforced without fear of favor. This sent a clear message that no lawyer, regardless of status or influence, is above professional scrutiny. This is particularly important where lawyers often play a significant role in public life. It ensures uniform application of ethical standards, preventing politicization or selective enforcement. Thirdly, the ruling affirmed that the Bar Council has the authority to initiate disciplinary proceedings even the client withdraw a complaint. The Bar is not limited to reactive complaint but can act proactively to uphold the profession's integrity. This solidified the self-regulatory role of the Bar as a guardian of the public trust. Lastly, the judgment played a role in restoring public confidence in the legal system. By upholding the Bar Council disciplinary power and reinforcing ethical obligation, the judiciary affirmed that the profession is serious about the self-regulation and accountability. This is vital in a climate where the credibility of institutions is constantly scrutinized. So to conclude, the stakeholding now firmly recognized as a fiduciary obligation. Secondly, misconduct does not require dishonesty or loss. The breach alone is enough. Intention is secondary. Then, the Bar Council can act independently and no complaints by the affected party needed. And the last point, it is clear that precedent that lawyers are trustee in many client-related matters. In sum, in the case of Dato' M. KBS and another and Bar Council, it reaffirmed that being a lawyer is a privilege, not a shield. And with that privilege comes a duty to uphold the very principle upon which our legal system rests. Thank you.